Thank you very much. Hello, everybody. I'm going to tell you a little bit about explainable AI now. I'm not quite sure if I see if somebody raises their hand or anything, so I'll just stop sometimes in between if you have questions. So what we're going to look at now, here it is firstly the right to explanation under the GDPR, which is the first legal instrument. And we have an associated court case, and then we have an interpretation of a data protection authority in Spain. And then we have another approach to explainability under the AI Act, which is much newer than the GDPR. And then we have the ICO guidelines from the UK and some closing thoughts. So firstly, what is the overall? I hope you don't see that. Okay. Firstly, what is the overall aim of an explanation? So the idea is that in order to understand whether a person has been mistreated, a decision was inaccurate, or there was faulty data used, the data subject, so the person that was treated by the AI system, has to have the right to see whether this data was accurate, whether it was processed in a legal manner, and then also to contest the decision. So if there is a loan decision, for example, the data subject should have the right to understand whether that decision was made fairly or not. In general, the idea is that an explanation should be given to the person. And the legal basis for this is Article 22 of the GDPR. So under the GDPR, we have specific rules for the processing of personal information. Personal information is basically any information that relates to an identifiable individual. And these identifiable individuals, I'm going to call data subjects. So any data subject shall have the right not to be subject to a decision. That is the first thing we have to look at. That is based solely on automated processing, including profiling, that produces legal effects or similarly significant effects. So these are our basic rules that we look at. We have to have a person. That person has to be subject to a decision that is based only on an automated system or profiling, and the output of that system should have significant or legal effects. So what is a decision? Firstly, this is important. So we have that Article 22 that I just read to you. That also means that generally we are not supposed to be subject to solely automated decisions. They're generally prohibited unless it's necessary for the conclusion or the performance of a specific contract where it is specifically allowed by law or the person has given explicit consent. So it's basically an exemption that you use automated decision making. And in order to arrive at the right to explanation, we take this general prohibition on automated decision making together with the right to access. So you've surely heard that under EU law, you have the right to access your information. If somebody's processing it, you can always send them an email and say, hey, I want to know which kind of information you're processing about me. And one of the articles that rules upon this is Article 15 of the GDPR. So Article 15(1)(h) that we're looking at here specifically directs to the Article 22 that we have just looked at. And it says, at least where this kind of automated decision making is done, the data subject shall have the right to receive meaningful information about the logic involved, as well as the significance of the envisaged consequences of such processing. So that is basically where we get the right to explanation under GDPR from. I may stop here shortly. Are there any questions? Okay, I assume it's fine. Okay, so now the question obviously arises, what can be such a decision that would be subject to the right to explanation? From the case law, we've seen that could be a loan approval. So if a bank makes a decision on whether to approve a loan or not, and they use only an automated system that, based on some kind of input data, makes a decision whether you get the loan or not, that would be could be an automated decision. Credit scores, we're going to see a case about that. Even the restriction of user visibility on social media has been found to be an automated decision. That was found in the Twitter case, where Twitter was basically, or now X, was restricting access to a social media account because that account was referring to a news article about EU regulation on child pornography. And just in referring to this child pornography, it was found to violate the usual policies, and they basically restricted access to that person and their account and the visibility of the account. And that went to court because that person found that this would be unfair because they were just referring to a news article. And the person actually got right. The court found that this is an automated decision. There was no human involvement, and that was a decision that was not valid in the sense it was unfair because it did not actually violate. That was the Twitter case, a pretty interesting case. Another thing that can be a decision is, for example, the deactivation of a work account on a platform. So as we know, there are a lot of services upcoming where the user, as much as the worker, are connected via a social media, not a social media, but a platform. For example, Uber is the case. You have Uber drivers using the app in order to get work, and then Uber users in order to get the Uber. And there's a lot of things to unpack here from a legal perspective, because the work accounts are oftentimes deactivated based on rules that are not intelligible for the workers themselves. And there were several court cases about Uber and Uber workers, where they're alleged that there was automated decision making when for example, their work accounts were deactivated. And actually, the workers won. However, there is no explanation so far on how it works. So these are still ongoing cases. Okay, now we're coming to the most interesting case within the GDPR system so far. The Article 22 and the right to explanation haven't been much in focus for courts. So this one is particularly cool. It's from February this year, and it is about a data subject called CK, and the company called Dun and Bradstreet Austria GmbH. And that is a credit scoring agency. And what happened was that CK wanted to make a phone contract worth 10 euros per month, and was denied to be able to conclude this contract based on a bad credit score that Dun and Bradstreet had given. So what happened was that the data subject went to the local authorities, to the Data Protection Authority of Austria, and asked for explanation of this credit score because he or she decided that they thought that this was automated decision making. In fact, the data protection authorities gave right to CK and decided this was an automated decision, and Dun and Bradstreet were in the duty to provide information. That would be the information that is processed about this person, together with how this credit score was made. After a long back and forth, the company didn't provide enough information to understand whether there was a mistake in this credit score or not. And it also didn't seem to relate to the actual information. So in the end, that went to the final court in Austria, and the Austrian court went to the EU asking, how shall we understand the right to explanation? The CJEU reminded that the purpose of this right is to allow the data subject to examine the scope of the data processed, the legality of processing, and to contest the decision. So the final aim should always be that based on this explanation, I can understand whether I have been treated right or whether there was a mistake in the decision made. The CJEU went further and argued that meaningful information in this course means the actual procedure and principles. So it's one element of content, what is the actual content of the decision and did we arrive at the content, but then also what are the actual steps from a procedural manner that we're looking at here. And it said that it's not enough to communicate a mathematical formula like an algorithm or just a detailed description of the steps that you take in automated decision making. And interestingly, the court proposed that it would be okay to accept explainability to be reached when you can inform the data subject of the extent to which a variation in the personal data taken into account would have led to a different result. So basically, the CJU is referring to counterfactual explanations and that it would be okay to accept those in this scenario. Interestingly about this as well is that the CJEU said that the meaningful information itself should provide the actual procedure and principles, which is very interesting when you think about the idea of having these secondary models for explanation, because that would not be the actual procedure. But we'll get to that a little bit later. Okay, so then we have, sorry, are there any questions until here? Okay, I hear nothing, so I assume it's fine. Okay, then we have an interpretation of this right to explanation by the Spanish Data Protection Authority. And they have brought up these guidelines on how to audit AI tools, which is pretty cool. And in referring to the right to information, they basically said that they would expect that the data subject would receive detailed information about the data that is used for the decision making, the relative importance or weight of each data category in the decision making, the quality of training data, and the type of patterns used, whether profiling activities were conducted and what are their implications, then error values with according to the appropriate metrics used to measure the eligibility of the inference, whether there was a human involved, and any kind of reference to audits or certifications that were performed on the AI system. So also that is pretty vague. But what I think is very nice is that they do refer to actual metrics to be used and not just to something very, very abstract. So I think we're getting closer to the actual explanations themselves. And then we have, if it moves, yeah. Then we still have the explainability under the AI Act. So the AI Act has, if you look at the provision, it's Article 86. The AI Act is applicable in all cases, not just where personal data is involved, but whenever you have an AI system. And what is super interesting here is that this explainability under the AI Act applies only for high-risk models. So high risk is, for example, systems that are used for employment, education, or law enforcement, migration, border control, stuff like that. So that's already a pretty limited scope of when you have to have explanations. But then when you look at the article again, you see that it's again about a decision that was made by an AI system that in this case is high risk, that produces legal effects or similarly significant effects. And in this case, they add in a way that would adversely impact health, safety, or fundamental rights. But what you can see is that in these cases, the data subject has a right to meaningful explanations of the role of the AI system in decision making and the main elements of the decision taking. So if you read it, you will find it's essentially the same rule as the GDPR when it comes to the content. It sounds very similar, and it's probably going to have the same requirements, I would guess. Then, right, as one of the last interesting points, because the AI Act in itself doesn't have any enforcement yet in which we could look at, but we have the UK disclaimer. It does vary here between the UK and the rest of the EU. I just took this out because we don't really have standard models of explanation yet. But the ICO was basically the only one that I could find that had actually a list provided with different strategies for explanation as opposed to the limitations. So if we shortly look at that, I think one of the explanation methods that everybody knows is LIME. And it says builds an interpreter model around a specific prediction approximating the decision boundary local, which in this case is very good because obviously we're looking not at a general explanation here. As we heard, it's about the actual decision that was reached in a specific case. So we want to have a model that can actually look at a specific case and not like a general architecture and understanding. And then the limitation, on the other hand, is sensitive to proximity measures, reliability drops with perturbations, and you can probably also add that it's not easily understandable for a data subject. And what this list in the end shows, you can also see that counterfactual explanations are named, but then also say can be arbitrary with feature selection, may not uncover hidden harmful interactions. So all of the explainability methods that we have in the UK, for example, would be to a certain extent allowed. That does not mean that that would be the case for Europe. But what is interesting is that it is acknowledged that depending on the specific case in which you want to reach an explanation, and you want to use automated decision making, there can be a model that is right, and there can be an approach to explainability that is not right. This will generally depend on the sensitivity of the matter, on the field in which you're using it. So, for example, when looking into the field of banking and insurances, you will assume that there is no way you can have a system that makes loan decides over loan applications or credit scores that does not involve a real solid explanation. On the other hand, what is also very important to remember is that um, automated decision making, firstly, is not always the best choice. And if you are able to keep human oversight over your decisions and you use the automated decision for recommendations to the human rather than for replacing the human decision, you will not have the same requirements for explainability, and you will have much easier time when it comes to compliance with the GDPR and the AI Act. And also consider that explanations always are dependent by a case-by-case analysis. So no matter in which way you're using it, you will still have to make an assessment case by case. That would be it from my side. I'm not quite sure how much time. Well, yeah, I'm pretty early. Are there any questions?
Thanks a lot, Diana, for this very interesting talk. I will now unmute the audience. Please raise your voice if you have questions or comments. So it seems that the main forms of explanations currently used in legislation is counterfactuals and this Lime method. Is this correct?
Um, well, you can't really say that. So, obviously, the fact that the CJEU said that counterfactuals would be a valid choice means that this one we're going to be fine with. Um, Lime, the example from the UK, as I said, is not necessarily acceptable in the EU. I think Lime will be valid in some sense too, but it inherently depends on the context in the end.
Thanks. And yeah, maybe another more general question. How important do you see, or how relevant is the regulation of explainability compared to data protection? So is explainability more like a nice add-on, and the really important thing is data protection, privacy protection?
Well, I think that explainability is one of the major factors leading to successful data protection. So you have to consider you have all of these rights under the GDPR that allow you to access information, understand what is done with your information, and so forth. But none of this is of any help unless you have a way to actually enforce it. And the right to explanation basically gives you that opportunity to get the information you need in order to enforce your rights and to say this is not valid, this is not valid data. So I think it's a major tool. I think it's one of the biggest and most important parts.
Okay, thank you. Are there any other questions or comments?
If I may add something, sorry. Okay, if I don't see any, oh, there is a chat question.
Sorry, just a moment. One of our students here has a question. Yes. Right.
Okay.
Yep.
Hello.
Hello.
Could you explain a bit more about the models? At the end of your lecture, you told about the model, but I don't
Yes.
understand about the model. Is it possible tell about something about models?
So I can show you this one again.
Uh-huh.
I'm not quite sure if I
In,
understand.
in the last.
Are you talking about this one?
Maybe you are referring to the machine learning model
Yeah,
that they use.
yeah.
Do you remember which slide?
Okay, so we're talking about this one. So okay. So we do have different explainability measures that we can use. At the moment, there is post hoc methods, and then there is the idea of inherent transparency. And basically, the validity of which model should be used is going to depend on a case-by-case basis. There is a longer list of these models by the UK that can be used. There's like different strategies. I added that into the sources in the very back, so you can have a look at this later if you wish to. But the basic idea is that we have models that are already more senior in the sense that they are in some standards. In some standards that you can find all over the world, you have Lime or the Shapley values. Um, So these two would basically be specifically for a decision. And these are like kind of standardized methods that you can use, but there is, as you see, there are still quite some limitations. But for maybe less sensitive matters, you could potentially think of using those. The counterfactual explanations basically just means that you are checking the changes in output based on a variation in input. And that can basically lead to an understanding of the data subject in the sense of you would have gotten the loan if you had 20K per year more in income. That would be, for example, a counterfactual explanation that might be quite good for banking situations, because obviously you have quite strict basic assumptions based on which you would give a loan or not. So for that, counterfactual explanations might be really good. But there is no overall acceptance of one specific model over the other. I don't know if that answered your question.
Yes, thank you very much.
Okay, Okay, so
Yeah,
I see two questions.
thanks.
Sorry.
Thanks a lot, Joseph, from my side for this interesting talk. I think one issue is also that there is not a generally accepted definition of what an explanation is. So I think that makes all of this, yeah, a bit complicated. Yeah.
Well, there is actually an accepted definition.
Is there?
Well, the definition is always the same. It's meaningful information about the logic involved. What nobody can really agree on yet is what fulfills that definition.
Yeah, but it's a bit vague. So this is also a problem that I'm having with this. Yeah, with this whole field, I would say that yeah, it's often more about techniques and methods that provide some form of explanations, but often we don't even understand the methods themselves. So I think the only one which is really theoretically rigorous is this, well, like based on Shapley values, but that, well, is computationally too expensive.
Well, I think there are a lot of different attempts. As I said, I put these ICAO guidelines in the back in the sources. They examined like 50 different strategies, and it's always like the way of explanation they provide together with the limitations. Again, not necessarily valid for Europe, but great to understand which strategies might be good for a specific case. But thank you for that. I'm just going to go shortly into the chat questions. Do you have any insights on what constitutes an AI model versus a non-AI model? Yes, that is actually defined in the AI Act, I believe. Generally, when we talk about AI model, the assumption is that you have an automated system that to a certain extent does not require okay, let me rephrase that. So the elements that we're looking at is that you have an automated system, one. Second, that it has a certain amount of independence in learning, so you don't need to teach something specifically. And I know the phrasing here is a little bit horrible due to the fact that it's not human learning, but this is the basic assumption. There is, in fact, a full definition on what AI constitutes in the AI Act. But I don't remember the article right now. I will search it out and maybe we can distribute it over. I will distribute it over the email chain that we have. It's pretty clear cut, I believe, but I will send it to you. then is there a middle ground between explainability that satisfies GDPR and preserving commercial confidentiality? That's actually a very great point. So there is, for example, in this Dun& Bradstreet case, there was one of the allegations that they did not have to provide that information on how the credit score was reached based on the fact that it was trade secrets. And what was found is that there is no requirement of completely disclosing your trade secrets. However, the way that it was solved now is that when you're alleging trade secrets as a company, and that is the reason for which you think you cannot give information, then a court will get access to your trade secrets, assess whether they think that those are trade secrets, and based on that, determine which information you are nevertheless forced to provide. So I think so far the enforcement has been more on the side of as soon as somebody alleges trade secrets, the case is done. Now we're moving into the direction that trade secrets firstly have to be examined by a court, whether they consist trade secrets. And then if they exist, you still have to provide that information that would not harm your trade secret or third parties' rights. I hope that answers that question. Okay. Are there any other questions? I don't think that is a...
Sorry, I have a question.
Yeah.
So for the case you were mentioning, was there like any XAI domain-specific tools that were used, or just general like AI tools like chat or Line or the others?
I'm sorry, you're a little bit low in voice. Did you ask about the case that I was mentioning?
Yes, yeah. So about the case you were mentioning, so were there like XAI explanations for like from a domain-specific tools, or were general tools used in that case?
So in the case that was decided in February, basically the CJEU said counterfactual explanations here would be okay. But this is an opinion given by a European court. The European court itself does not decide over the court case itself. It's going back to the Austrian courts now, and they can give further recommendations, which has not happened so far. So the actual explanation in this case has not been given out, and therefore I cannot tell you which system they used in order to provide such an explanation.
Yeah, okay. Thank you.
Okay, any other questions? Oh, okay. So we have another question. Does this mean that all European companies running regressions on their Excels are now building explanation models? I'm not quite sure what you're referring to be honest. You have to consider that explanations are needed in circumstances where you're fulfilling Article 22. So you're making a decision about a human being. That is completely automated. There is no human involved in the decision making, and then it also has significant or legal effects. I don't know what kind of Excels you're running, but I think it's also important to understand that this kind of explanations are not required for every little thing that you do. They are required when it's really important for the people whose data you're using to be secured in a sense, because that might impact their livelihood. So that's not just going to a bakery and getting a random number. That's really things that can have a significant impact on a person's life and potentially destroy it. So for that, we really want to have explanations, but let's not take it too far. Oh, now I'm seeing that it was a joke. I'm sorry. Maybe that was a really long answer then. Okay, any other questions?